Police applications for intervention orders. I could tell you now, as I tell all my clients, they're very, very difficult to overcome. When police apply for an intervention order, they usually do so on the basis that there was a police report in the first place and they're trying to mitigate risk. Of course, I can understand that. It's a reasonable position that the police maintain, and they will always ensure that the application is finalised in some sort of intervention order. It doesn't have to be a full order. The police will take their time, of course, to contact the AFMs or the protected persons and ask them, hey, do you want an intervention order? That's on the basis of the initial intervention order. And if that intervention order runs through for that 12-month period or however long it is, and the respondent has not committed any breaches of that intervention order, then I would say, and on a reasonable level, I think common sense would also dictate, that there is no basis for an extension. But oftentimes I do see extension applications. And that is an application to extend the intervention order beyond the original term, the 12 months, 2 years, however long it was. Now, when there hasn't been a breach, what's the basis of the extension? Well, you can't just base an extension on the speculations of the respondent or the police. Or the respondent might engage in that behaviour because he's engaged in that behaviour in the past. Wasn't that the basis of the initial intervention order? If the risk hasn't been encroached upon or breached in any way, then there's no point in trying to mitigate the risk any further. The risk has been mitigated. Everyone got the point. So, with extensions, especially when there's no basis, there's no breach, oftentimes the police don't usually proceed with those when they find that they are based maybe either on something frivolous or they just can't really justify it in court. It's a very crucial issue of public interest here. Intervention orders are designed, of course, to mitigate the risk of family violence because that's in the interest of the public. When extensions are sought, when there is no breach of an intervention order and no purpose or no reason to try and mitigate the risk, then you move away from a public interest and you start to consider what the personal interest might be. And if it's the personal interest and we start to think, what's the interest of the AFM to have an extension application? We start to think, well, maybe there's something maybe a little bit vindictive there. And I start to think that this intervention order is now being weaponized against a poor respondent who's done everything they can to ensure that they've abided by the intervention order and not committed further family violence, as was the point in the first place. But just keep in mind, police applications rarely ever get withdrawn. Your best bet is to try and negotiate them down to something basic, and that's really based on the sentiments of the AFM or the protected person. Extension applications, though, would have to have some sort of breach within that time period of the intervention order, otherwise they're frivolous, and your best bet is to contact Marcellus Law to try to get those applications thrown out.